Welcome to War Story Wednesdays. Today, I want to revisit a case from 1925.
Who can brighten darkest skies? Who can dry my tear-dimmed eyes? Nobody, nobody but you.
Some things don't change. Like people who want to buy property in Palo Alto and who have real estate brokers from San Francisco. And that's what happened here. And so the customer with the broker went down to go look at some property in Palo Alto and found just the right place. And when asked, oh, how much do you want for it? The real estate broker jumps up and says, $6,125. If only that were the case today, right? And the seller is sitting in the living room of the house and nods, and the buyer says, okay, I'll do that deal. And looks to the seller and says, so how do you want to do this? And the seller looks at the buyer and says, talk to the broker, deal with him. And off they go. And the buyer turns around and writes the real estate broker a check for $3,000 and arranges a loan for the other $3,100 and gets ready to close, and the broker takes off with the money. So the buyer would like either to get the money back or close the deal, and the seller doesn't want to close the deal unless he's going to get the full $6,000. So they have a problem. And the buyer sues the seller for return of the $3,000 that the buyer had given the broker. And the seller said, well, wait a minute. He was your broker. He's your problem. He wasn't my broker, not at the time that you came to the house and made the deal. And it turns out that there was no listing agreement, and that the real estate broker on that first day didn't have any contractual agreement with the seller of the property at all. The day after the buyer and the seller met at the property, the seller entered into a commission payment agreement with the broker, but that was after. That wasn't before. So there hadn't been a pre-existing relationship. And the trial court didn't know what to make with that one, and of course it went adversely, and there was an appeal. And the Court of Appeal struggled just a little bit and said, well, it's true that the buyer met with the broker in the first instance, but that's generally what happens. And it's true that the broker went down to the seller and said, I got somebody that wants to buy your house, and that's also what happens. And it's true that there was no official written agency agreement between either one of them. So who's responsible for the loss? The Court of Appeal said the triggering moment in this transaction was when the seller was sitting in the living room and looks to the buyer, and in response to the question from the buyer, who do we deal with? The seller pointed to the broker and said, do business with him. At that moment, the seller made the real estate broker the seller's representative. And when the buyer handed the money over to the broker, that was the same as handing the money over to the seller. And the seller was found responsible for returning that $3,000. It's called ostensible agency. It's when you allow a third person to believe that this guy over here is authorized to act on your behalf, whether there's a written agreement or not. And if that third person exercises upon that representation and does something with the person you've said is your agent, then you are responsible for what your agent does, even if it's taking the other guy's money.